I'm Michael Kelly, Interim Dean of the School of Law. Welcome to Creighton University on this very special day, set aside to recognize the memory of Dr. Martin Luther King Jr., celebrate his legacy, and rededicate ourselves to furthering the common mission he inspired us as a nation to strive for on a late summer afternoon in August 1963 on the steps of the Lincoln Memorial. Our program today is designed to further that important civil rights conversation. As a Jesuit law school, we are focused on forming compassionate young attorneys who seek to make the world a better place. We are also interested in how new policies can become legal obligations that move our society forward. For both of those reasons, we are thrilled to bring you two attorneys who have worked tirelessly to realize Dr. King's dream in the legal world. One, a civil rights icon, and the other, a celebrated federal prosecutor. Together with the Vice President of our Black Law Students Association, they will give us both a retrospective and a prospective view. My personal thanks go out to Ken Reed Bowie of the Schlegel Center for Service and Justice, Reverend Tony Sanders of the Interdenominational Ministerial Alliance and his partners, and Chris Rogers, Emily Beller, and Tori Van Hoevelen of Creighton University for making this event happen. I also want to recognize our provost, Dr. Tom Murray, who's joining us today as well, and the Lane Lecture Series, of which this is a main component, is made possible through the generous support of the Lane Foundation, whose representatives are here today as well. The Lane Lecture has been a hallmark of the law school's intellectual life for decades, and we have presented other leaders in this field, such as Ted Shaw, General Counsel of the NAACP, and Professor Charles Ogletree of Harvard University, and we're proud to continue this tradition today with Reverend Gray. It's now my pleasure to introduce Father Daniel Hendrickson of the Society of Jesus for a special welcome and presentation. Father Hendrickson became Creighton's 25th president in October 2015. A native of Fremont, Nebraska, he was educated at Marquette, Fordham, and Columbia. A firm believer in the Ignatian vision of global engagement, he created the Global Initiative upon assuming the presidency of Creighton, an initiative that takes students and faculty around the world to broaden their experiences and brings the world back here to Omaha as well. Father Hendrickson is uniquely equipped to blend this local outreach with native Midwestern roots overlaid with Jesuit values and understanding. His prioritization of the university's diversity efforts stem directly from that dynamic. We are grateful that he came to us as our new president precisely at a time that we as an institution were ready for his leadership and vision. Please welcome Father Daniel Hendrickson of the Society of Jesus.
Thank you very much, Dean Kelly. Good afternoon, and on a very cold day, an exceptionally warm welcome to all of you to the 2018 Lane Lecture, sponsored by the Creighton University School of Law, the Omaha Interdenominational Ministerial Alliance, and the Schlegel Center for Service and Justice. Thank you very much for being our guest on Martin Luther King Jr. Day for this important portion of our celebration of the work and the legacy of Dr. King. We are particularly honored that Reverend Gray is gracing us with his presence for today's program, Civil Rights Then and Now, a conversation with the Reverend Fred Gray. We are thankful also for other panelists, alumnus Greg Rhodes and student Kai Wareham-Harry, and our moderator, student Sei Olowelefe. I think I got that right. Thank you for being here today, and we look forward to this important conversation. As you know, today is an occasion for Creighton to confer one of our university's highest honors, the Presidential Citation. Reverend Gray, would you please join me here at the podium? Reverend Gray, preacher, civil rights activist, and attorney, has played a central role in the American civil rights movement. Born in 1930, he studied law at Case Western Reserve University and vowed to work to end racial segregation in his home city of Montgomery, Alabama. In 1955, he took on cases of Claudette, Colvin, and Rosa Parks, who were charged with disorderly conduct for refusing to move to the back of the bus, sparking the Montgomery Bus Boycott that protested segregated public transportation in the Alabama capital. He also litigated several more high-profile civil rights cases, including work to help establish the NAACP in Alabama and to desegregate the state's public schools and institutions of higher learning. In the 1970s, Reverend Gray represented plaintiffs who had been unwitting subjects of the Tuskegee syphilis study. He filed a suit on the men's behalf, achieving a settlement in 1975 that provided proper care for his surviving clients. In 1997, President Bill Clinton offered an apology on the government's behalf, and the Tuskegee Human and Civil Rights Multicultural Center was established, for which Reverend Gray later served as the president. In 1985, Reverend Gray was elected president of the National Bar Association. In 2002, he became the first African-American president of the Alabama Bar Association. His autobiography, Bus Ride to Justice, was published in 1994 and updated in 2012. In honor of his notable achievements in the cause for civil rights, Creighton University proudly confers the Presidential Citation upon the Reverend Fred Gray this 15th day of January 2018. Please join me in congratulating Reverend Gray. And again, thank you for joining me here today. And the Reverend Gray would like to just offer a quick response.
Mr. President, ladies and gentlemen, I first want to thank the President and thank this university for giving me your Presidential Award. I'd like to acknowledge the presence of my wife, who's here, and she travels with me. I'm just happy to have her. But I want you to know that the work that I have tried to do for the last 63 years, as I begin to read a little something about university, we are trying to do the same thing. We saw a problem when I was a teenager that needed to be worked on in Montgomery, decided to become a lawyer would be the best way to do it, and proceeded to try to solve those problems, and that's what you're doing. I accept this award on behalf of all those clients over a 63-year period who gave a young lawyer of African descent an opportunity to represent them. Not so much the ones that you know about, like Dr. King and Mrs. Parks, but the ones you don't know about, like Claudette Colvin, the 15-year-old girl who did what Mrs. Parks did, but did it 9 months before. It is on behalf of all of those persons that they talked about in the introduction and in the citation that I accept the award, and particularly on behalf of those unknown persons, including those men in the Tuskegee syphilis study. And from your city and your state, you had some persons in the Tuskegee Airmen. I would like to give you, Mr. President, a copy of Bus Ride to Justice. While it is my autobiography, it is really a history of the civil rights movement as it developed from Montgomery forward. I also would like to give you a copy of one of our brochures on the Tuskegee Human and Civil Rights Multicultural Center that you refer to therein. And finally, I'd like to give you a copy of the 20th anniversary of the Presidential Apology and the 20th anniversary of the Multicultural Center and invite you to visit with us. Thank you very much.
Thank you very much. Thank you. Glad you're here.
Thank you, Mr. President. And now we turn the platform over to Shea Olawafi, who will moderate and introduce our panel, the president of our Black Law Student Association at Creighton Law School.
Wow. How do you follow that? Thank you, Father Hendrickson, and thank you, Dean Kelly. On this day, as we acknowledge the contributions of Dr. Martin Luther King, Jr., it is important for us to remember that justice and equality starts with each one of us. It was Dr. King who said, "Human progress is neither automatic nor inevitable. Every step toward the goal of justice requires sacrifice, suffering, and struggle. The tireless exertions and passionate concerns of dedicated individuals." As this year marks the 50th anniversary of the founding of the Black Law Student Association, I can think of no better way of commemorating this occasion than by having this distinguished panel encompassing a generational spectrum to engage in a dialogue about civil rights that is just as relevant today as it was over 50 years ago. As a Creighton chapter president of the Black Law Student Association, it is a privilege to introduce the remaining panelists, Mr. Greg Rhodes and Ms. Kai Worman-Harry. Mr. Rhodes is a 1981 graduate of Creighton University School of Law, as well as a former assistant United States attorney. Mr. Rhodes' roles and life experiences have included being a husband, a father, a grandfather, and a mentor for all those that he's taken under his wing. And then there's Ms. Kai Worman-Harry, who is a class of 2019 Juris Doctorate candidate of a Creighton University School of Law. She's a member of the Creighton Law Review, as well as a member of the Frederick Douglass Moot Court team. And most importantly, she is the vice president of the Creighton chapter of the Black Law Student Association. Can we please give a round of applause to the remaining panelists? It is with my hope that this dialogue inspires us as individuals, as community, as a nation, as a society, as a race of humans, to be passionate, dedicated individuals that strive for justice for all mankind. Thank you.
Thank you, Shay. Reverend Gray, you mentioned this generational gap here between the three of us. And one of the things that struck me while I was reading your book is that I'm 70 years old and I barely remember, because I was about 9 when all of the events started in Montgomery with the boycott and whatnot. I want you to explain to this audience the mood in the South in 1955 when Mrs. Parks made her historic protest. You defended her. What type of violence and intimidation were you all facing at that time in Montgomery?
Well, what you have to remember, and it's difficult to try to explain to you the mood of the South when I was growing up. But what you have to remember is that there was a time not so far away, and some of those things that exist then still exist today. But I grew up in Montgomery, Alabama, which is now the cradle of the Confederacy, where Jefferson Davis took the oath of office. It was a time and conditions where everything in the South and in a substantial part of the other part of the country where there was really at least two worlds. You had a black community, and we've been called various things at various times, from Negroes to colored to African Americans to blacks. But you're referring to those persons who were brought to this country in 1707 as slaves and who had to work their way from there to where we are today. But when I grew up on the west side of Montgomery, which was the ghetto area, I didn't know anything about white people other than, and my father died when I was 2, the youngest of 5 children. My mother had no formal education, but she taught the 5 of us something, and that was that we could do whatever we wanted to do if we did 3 things. Now, it's taken me a little time to answer your question, but you have to understand the climate and what took place. Mom told us that we could be anything we wanted to be if we did 3 things. 1, keep Christ first in your life. 2, stay in school and get a good education. And 3, stay out of trouble. Don't get involved in this criminal justice system. She didn't say it in that way, but she was telling us that the criminal justice system does not always result in it. Everything in the community where I grew up was black. I would go to a black school, a black church. If we had a grocery store in the community, usually a white person ran that grocery store, and black people worked for her. My mother did domestic work for a white lady that we called Miss Betty, who she was working with at the time that I was born. So the only relationship basically that blacks had with white was a employer-employee relationship. So there was no equality, there was no profession of equality. Is that white folks did what they wanted to do, and black folks did what they had to do. So we were living in a completely segregated time. And added to that, there were state statutes and city ordinances which required the 2 races, the white race and the black race, to be separated. That is the condition that existed in the South when I was born, during my teenage age time, and through the time that I finished college at Alabama, what was then Alabama State College for Negroes. I hope I answered your question. It's a long one, but it's a long time.
Well, Reverend, it's demonstrative of what you talked about in your book and how the struggle started. Now, Kai's got a question over there for you also.
So, sorry, hearing my voice. So, Reverend Gray, you in your book describe what your experience was like coming from such a humble background and arguing in front of the Supreme Court. Can you go over and describe to the audience what the preparation was like for you, as well as attorneys like Thurgood Marshall, in having to argue in front of, in the highest court of the land on the issues of the utmost importance of that time?
Answer your question again. I have a little hearing problem. I want to be sure I'm following it. Go ahead.
So I was asking, you talk about in your book what your experiences were like arguing in front of the Supreme Court.
Okay, I know what you're asking me now. Yeah.
Part of that, we've discussed, you were a very young man.
What happened is, in the case of Vermillion versus Lightfoot, let me give you a little history about the case. And I started practicing in Tuskegee. It's quite a historic place. It's where Booker Washington started, what is now Tuskegee University. But you've always had, for a long period of time, a large percentage of the population was African American, about 80%. But that developed over time. Tuskegee what is now Tuskegee University. Then there was a VA hospital that came into being after the World War I, because there was no place for veterans to be treated, black veterans. So the university gave to the government 300 acres of land, and they brought a VA hospital there. And that VA hospital was being operated for blacks, by blacks. So you had there highly educated persons at Tuskegee. You had highly educated persons at the VA hospital, black, but they couldn't get the right to vote. So they had white people who were controlling the political process, who would not permit them to vote, but they controlled their whole life. So there was a long process involved, from filing lawsuits by private individuals to finally the federal government. Then about 1957, when there was a city election coming up, and as a result of some litigation that has occurred over a long period of time, blacks had about 300 or 400 voters in the city limits of Tuskegee, and they didn't have enough to elect a mayor and city council, but they had enough to make the difference that whoever they supported would win. But the state senator, Senator Engelhard, who lived in Shorter, which was in Macon County, came up with an ingenious device to keep the blacks who were registered in the city election so they could not vote. He changed the city limits of the city of Tuskegee. Tuskegee was a square, I think 3 miles from the courthouse. It changed it to what I described in a lawsuit I later filed, Gomillion versus Lightfoot, and that's the one you're talking about, and I'll get to the argument in a minute. But what happened, I described it as a 28-side sea dragon going out to include whites and coming in to exclude blacks, so that they ended up where all of the blacks, the 400 and something, except 4 or 5, were excluded from the city limits. None of the whites were included. And they said, you still have the right to vote. You can vote in county elections. You can vote in state elections. You can vote in federal elections. But you cannot vote in city elections, not because of your race, but because you don't live in the city anymore. Very ingenious. And there was a case, Hargrove versus Grove, that involved some congressional district that Mr. Justice Frankfurter on the Supreme Court had written the opinion in. And it said that the matter of setting these judicial political subdivisions was a political question, and the courts would stay out of that figure. I had to go, and I went to the NAACP. They had helped me in the bus boycott. And then when they excluded the state of Alabama, I had helped them. I went to Bob Carter, who was Thurgood Marshall's assistant, and asked him to help me with this lawsuit. And Bob said, well, for Cold Grove versus Green, I don't think we can win it. I kept on and said, well, let me try to draft a complaint and send to you and see if you won't help me. He said, well, I'm going to be meeting with a group of lawyers. He was then the general counsel for the NAACP in Dallas, Texas. Draw up your complaint, bring it out there, and I'll look at it. And I did. And he agreed to assist me. So, as I went up to the Supreme Court, I believe it was on a May day, in arguing that case, I looked up and saw it was talking about equal justice under the law. And I remembered a professor I had in law school in constitutional law. And he said all the time, we shall see. So I went up there, and as I looked up, I said, we should see. Because here I am, only, 20 25, 26 at the time, we argued the case. Going to the Supreme Court, never even dreamed of knowing anything about the Supreme Court before then. Now I'm about to have an opportunity to argue a case before that court. But I had enough sense when I was preparing the case and preparing my complaint, right after I was retained. I told the executive director of the Tuskegee Civic Association, which was the organization in Tuskegee that sponsored all this litigation. I said, I think the best way for me to illustrate the effect of this is to have a map and have on that map, an official map, superimpose the old city limits and the new city limits. When I filed my complaint, I had enough sense to attach a copy of it to the complaint. I had a big map that I was going to demonstrate to the court, but I never got a chance to use it because Judge Frank M. Johnson, Jr., who had ruled with us in the case of Browder versus Gale, which was the bus desegregation case, and had ruled with us in some other cases, he dismissed my complaint, said it was a political question, that the court did not have jurisdiction. But we appealed it to the Court of Appeals, and that court, I was able to get one of those justices who dissented from the other two. While I lost it, he gave us a road map on how to write the brief and how to prepare the petition for certiorari to the Supreme Court. We followed his road map. But one thing that helped me, and that's what you wanted to know, how do you prepare a case like that? I had enough sense when I was retained by the MIA to get and contact Thurgood Marshall, and he and Robert Carter and the NAACP worked with me on all of my cases. So as a part of our preparation, Robert Carter, who later became a United States District Court judge in Manhattan and just died about 4 or 5 years ago, convened a meeting in Philadelphia with some of the most brilliant lawyers in this country, Mr. Colvin and Bob Carter and Bob Ming from Chicago, and a lot of other professors from the Howard Law School, and they prepared us for that preparation. So as I walked up the steps, and as I went to see how justice was going to take place, I felt, while I was young and inexperienced, I felt I was well prepared in order to do it. And one of the issues that the lawyers were concerned about as they prepared, I argued the case, and so did Robert Carter. But I was the young kid on the block, so they let me go first. And I had, as I went up those steps, in one hand a briefcase, and on the other hand, I still had my map, but I never had a chance to use. I talked to the clerk of the court and the marshals, and asked them, before I get up, will you please prepare this map so the court can see it. It was a part of the exhibit to it, so they did it. As soon as I got up and addressed the court, and I was afraid, and before I could start into my prepared argument, Mr. Justice Frankfurter asked me a question. And he was a judge we were afraid of because of Colvin versus Green. He says, "Counsel, what is that behind you?" I described to him about this map, what it was, how it was superimposed, what was the effect of it. And he says, "Where's Tuskegee Institute?" I pointed out Tuskegee Institute. He says, "Tuskegee Institute is in the city limits of Tuskegee as this act has redefined it, isn't it? I said, Mr. Frankfurter, it was in the city limits, but this act excludes Tuskegee Institute from the city limits. He says, Tuskegee Institute is not in the city limits of the city of Tuskegee? I said, no, sir. I think that got not only Justice Frankfurter's vote, but a unanimous vote in the case of Vermillion versus Lightfoot. Now you know the rest of the story. It's a long way around, but that's it.
It's a great way around.
Mr. Rhodes, do you have any questions?
I do. I'm laughing about that because you went before the Supreme Court at 25. Thurgood Marshall went before the Supreme Court at 25. If I am correct, Constance Baker Motley wrote the original briefs for the Brown versus Board of Education cases, and she was a young woman. So all of you who have led us into what I consider, you led us through the golden age of civil rights, were young people, just barely out of law school.
Well, you know, the historians point those things out, but when you're going through it, you don't really think about your age other than, in my case, I can't say about others, I knew as white people in Alabama were going to have the best lawyers they could get on the other side, and I didn't think that Fred Gray would be able to cope with those lawyers with their experience. That's why I got Judge Mr. Marshall and asked him to give me anybody to help me, and that came Robert Carter. And on all of my civil rights cases for the next 5 or 6 years, you'll see I retained Arthur Shores, who was the black lawyer in Birmingham, who had been handling cases long before I had done it. I learned, and my advisor in law school, Professor Sonfield, when he tried to get me to stay in Cleveland, and I said, I won't stay in Cleveland because I intended to go back to Alabama to practice law. I didn't tell him what kind of practice, but to practice. He said, well, let me tell you something. Don't be afraid to share a fee with a lawyer who has more experience than you. I kept that in mind, and for 5 or 6 years, I shared fees with lawyers. Not that I thought I was so inferior, but I thought just to have them there to even tell me I was doing what was right or doing what was wrong, that helped. I didn't realize that those other judges that you talked about, lawyers and judges, because they developed into that they was that young too.
Let me ask you another question here. We've talked a bit about Alabama State earlier in the day. I would like you to talk about the continued effect of Alabama State Teachers Association versus Alabama Public School and others, because that case, when you look at the HBCUs now, and what that case stood for and what you were trying to accomplish there, will you talk about how it's evolved and what's happened as a result of that case, and give the audience a little bit of background on that case?
All right, let me give you a little background. Because you know about Brown versus the Board of Education. 10 years after Brown versus the Board of Education in Alabama, we still didn't have any desegregation of any schools. There had been an attempt to integrate the University of Alabama with Arthur and Lucy. But when the court ordered them in, something happened, and then they expelled her, and we didn't get in. There had been no desegregation of elementary and grade school. So the NAACP decided that they would encourage their branches to file lawsuits to enforce Brown versus Board of Education. So those cases, in '63, I filed about 5 of those. Same time, I filed a case to desegregate the University of Alabama in '63, and Auburn University in '63, and the University of North Alabama in '63. So we then had some institutions of higher learning when it came down to the time that the Alabama State Teachers Association filed this suit against the board. In Montgomery, Alabama State College, the historical black school, at one time was the only state-supported school in the city of Montgomery. You had, excuse me, several other private schools. University of Alabama had had an extension service in Montgomery. But white people wanted a state university in Montgomery because they didn't want white children to have to go to Alabama State, which was the only state-supported school there. But state was there, it was ready, and it was able to receive everyone, and under the law then, it should have been desegregated. But the Alabama legislature passed another law creating a governmental agency to establish Auburn University in Montgomery. Now we felt that the establishment of a historical white institution in Montgomery would in effect prohibit Alabama State from developing the way it should be, where whites should be able to come to it. We filed a suit. It went to Judge Johnson. And Judge Johnson ruled against me in that case. Well, I've been successful in getting Judge Johnson reversed in Gomillion v. Lightfoot earlier, and I was hoping we could have gotten him reversed in this case. But he ruled against us. He in effect said that the state of Alabama has a right to establish a university wherever it wants to establish it. It's going to be free and open to whites. It's going to be free and open to blacks. But this court cannot and does not have the jurisdiction to say to the state, you can't establish another institution here. He ruled against it. As a result of that, not only did Auburn University, and Auburn is about 60 miles from Montgomery, establish a university in Montgomery, but then Troy State College, that was located 50 miles from Montgomery, south of Montgomery, established a Montgomery branch of Troy State in Montgomery. And now you have, in the city of Montgomery, 3 state-supported institutions. No, let me go a little further. After the court approved Auburn to establish the University of Auburn in Montgomery, then the University of Alabama wasn't going to be outdone by Auburn. And they already had the university in Tuscaloosa. They had the medical school in Birmingham. They wanted to go to the Rocket City, Birmingham. So the University of Alabama started the University of Alabama in Huntsville. So, and I conclude in my book that the real unfortunate part of that, if we had won that case, there would have been no Auburn University in Montgomery. There would have been no Troy University in Montgomery. There would have been no University of Alabama in Huntsville. But we lost it. And I have been told, and I don't know how true this is, by some people who supposedly have been very close to Judge Johnson, who in his latter years said that they believe one of his worst cases was his decision not to do that, because what it has done was perpetuated segregation by having 3 institutions there, and it gave rise later to the case of Knight versus the state of Alabama, where a lawsuit was filed against all of the institutions of higher learning because you have duplications, and then Alabama State, the historical black school, and Alabama A&M were given some substantial financial resources that they didn't have before, and they obtained university status.
Okay, you have one?
Oh, well, I was going to ask, you've talked about before, or you've talked earlier about the Tuskegee syphilis case and the Tuskegee syphilis study. Can you hear me? The Tuskegee syphilis case?
I'm sorry.
The Tuskegee syphilis case? The Tuskegee syphilis case?
The Tuskegee, she's
That's
asking
a
about.
Tuskegee syphilis study.
Yes.
All right.
Would you like to talk about the case and the implications?
Let me give you a little something, because most of you don't know anything about the Tuskegee syphilis study. So unless I give you a little of the history, you won't know what's involved. But don't be afraid. I didn't know anything about the Tuskegee syphilis study until, 1975. And I had lived in Tuskegee since 1965, and I had practiced law in Tuskegee since 1955. But in 1932, the federal government, let me go back a little before 32, in the latter part of the 20s, the Rosenwald Foundation had decided that they found in 5 southern states, including in Alabama, some areas where there was a great deal of syphilis in individuals. And they had treatment programs for these persons. But they tell me that at that time, the treatment for syphilis was sometimes worse than the syphilis itself. So it was very crude. In any event, they decided in 1932 to discontinue all of that. There were some young white doctors who were employed by the United States Public Health Service who were aware of what the Rosenwald Foundation was doing. They knew about this Tuskegee syphilis. And they thought it would be a good thing if they could have a study of the effect of untreated syphilis in the Negro male. Now, there had been, I understand, a study some years before of white males the effect of syphilis over in Sweden. So these doctors decided they would do that. They went to the Surgeon General, and the Surgeon General gave permission for that to take place. So when they did it, they had a white county health officer in Macon County, the county seat, where Tuskegee is the county seat. And then they got a black nurse. You didn't have many black nurses in Alabama in 1932 to serve as his assistant. And they sent out leaflets to the churches in the black community, basically in rural areas. They didn't circulate any of these circulars to the black churches in the city of Tuskegee. And it told them about a new health care program and was recruiting black men to it. They told them that they would be able to see a doctor. And many of these men, most of them, if not all, had never been treated by a doctor. Whatever little ailment they had, most of them were farmers. So they said at first it was going to be for a short period of time. They didn't tell the men it was a study. It didn't tell them anything about they had syphilis or whatever. They gave them the impression that whatever they had, they would be treated for it. They didn't tell them anything so that they would have the knowledge or enough knowledge about it to decide whether they wanted to or not. The impression that was given and that they received was that whatever health was wrong with them, this would help them. So these men felt, if it's going to help improve my health care so that I can take care of my family, I will do it. The plan was simple. They were going to select a certain number of African American males in each community, in the rural communities. Some would have syphilis and some would not have syphilis, and not treat any of them, but just give them some, whatever they gave them, but it was nothing to treat them for the syphilis, and then watch the effect on it. And this existed. It started out to be short-term, but it lasted some 40 years, from 1932 to 1975. I ended up finding out about it. I had been to Washington, I think it was in July of 75, I believe the year was. And when I was on the plane coming back, I was reading a newspaper article, and I think the Washington Post, with a reporter named Gene Heller, was writing about this syphilis of Negro males in Macon County. Well, I was living in Macon County, and I didn't know anything about it. I had some good MD medical doctors there. They hadn't told me anything about it, so I said, well, I don't know. A couple of days later, I think on the 27th of July, 1975, a man named Charlie Pollard came into my office, and he had with him a copy of the local newspaper. And he says, well, lawyer, I don't know whether you've seen this story. He says that I'm one of the men that was in this program, and I think my government has taken advantage of me, and he wanted to know whether or not I would be able to help him. That was my introduction to what later developed into what they call the Tuskegee syphilis study. I told him I thought we could. I told him to go and to contact all of the other men that he knew who was in the study, to bring them into the office so that we could interview all of them and try to plan what needs to be done. So I got started. That was my introduction. And I realized then that when you're dealing with the federal government, it's not like the average client. They have all the resources of the government against you. And I tried to do like I did with these other civil rights cases. I went to the NAACP. At that time, Jack Greenberg now is the director counsel of the NAACP. And I talked with him. We had been handling a lot of school cases together. And he said, well, Fred, I want to help you, but this case has the potential of being a fee-generated case, so we can't help you. Well, I knew I needed a couple of things on this case. One, I needed somebody who could really help me do the research and help me prepare the pleadings and help me prepare the briefs. And I needed to have the money to do the investigating with it and to pay the filing fees, because these men didn't have anything. I tried law firms all over the country, plaintiffs' law firms. I couldn't find anybody, and I was willing to share a fee, but they would have to defer the money because I didn't have the money to finance the case. So finally, Jack Greenberg told me, he says, well, I tell you what, Fred, the NAACP Inc. Fund can't help you, but I believe the Dean of Columbia Law School, Dean Colvin, may help you, and one of his professors may be able to do it. So if you can't get from one source everything, you get what you can and put it together. So I reached an agreement with those men, and they agreed to help me with pleadings, help me with the briefs, do anything else they could do from New York, because I knew Judge Johnson now. I've been practicing before him, and as soon as you file a lawsuit, he is going to work you to death and getting that case ready for trial. And if you're not ready, he's subject to tell you he needs a brief, and he may tell you he needs it in 24 hours. Well, he may give you 48. But in any event, they agreed to give me the legal work. I still needed the finance. I then went to my local banker, Mr. Parker, man I knew, a fellow churchman. He was white, but well respected in the community. And he says, and I borrowed money before him and had paid him back. And he said, well, Fred, the bank will lend you some money, but it won't do it on a continuing fee basis. He says, you're going to have to pay the bank whether you win or lose. But what I will do, I will draw up the note in such a fashion that none of the payments will be due until you know whether or not you're going to get some money or not get some money. Well, at least now I can get the money to finance the case. So that gave it to us. We filed the lawsuit, make a long story short. And as soon as it was filed, and I filed it within 1 year from the time, I had to do it under the Federal Tort Claims Act. You can only sue the government under circumstances that the government say. And we did all right till we got to the discovery aspect. I filed my request for discovery. And I get this statement back from the federal government saying, we know there was some record somewhere. We have had our people to check. The Public Health Service don't know where the records are and don't know where they are. So we don't know where the records are. Don't know, so you don't have any records. How am I going to prove a case when all the records that were made was by the federal government, and now they say they don't have them? Well, thank God for the press. It came out that all this story now is in the newspapers, and there was a professor, Jim Jones, in Washington, D.C. I get this call from a man. He says, my name is Jim Jones. And he said, I think I can help you. I understand you represent these men in the Tuskegee syphilis study. He says, I think I know where the records are that you're looking for. And I'm willing to tell you where they are. And he didn't charge me anything. I said, how can I get to where you are and find out where they are? He told me, I went to Washington. We found those records scattered in the National Archives in 400 and some boxes. He was a person who had been a researcher in syphilis and had done a lot of work in that area and had become a good friend to some people who worked in the area and who told him where he could find the boxes that had that information, and he shared it with me. Once we received that information, and once I reported to the court, and the court ordered the government to go and get them and make it available, when you then go through those records and you're able to see how the government willfully mistreated and withheld treatment from these people, the government then decided, well, maybe we better try to settle this case. And that was the beginning of the settlement of the Tuskegee syphilis case. Now, what was your question? I hope I have answered it.
Shay is going to ask some questions of the audience, but thank you very much for this interplay between us. It was very important. And,
Thank you.
Enjoyed it very much.
Thank you very much. Sorry it took so long to do it, but it took 40 years, and it's been now about 60 or 80 years almost since then.
At this time, we want to open the floor to the audience for any questions the audience may have for Reverend Gray. Sorry, I cannot see you, so if you have a question, raise your hand and we'll send a mic down to you.
You have to repeat most of these questions for me. Okay.
Good afternoon. My name is Spencer Danner. I'm soon to be a candidate for Secretary of State for the state of Nebraska. And you talked earlier about gerrymandering and redistricting. My question for you today, what types of issues that are suppressing voters today that you're seeing that are more out of line of what was happening in the past that are still happening today to suppress voters to have an opportunity to get their chance to vote?
Well, of course, we've had the same problems in Alabama that's in most of the states, and that is you've had a lot of these voter identification laws and anything else that comes out that require people to do anything other than, all you want to be sure is that, number one, a person who is qualified to vote and on the voters list, if the name is there, then that they are that proper person so that you're not voting somebody who isn't there. But we've had any number of laws passed that have made it more difficult in terms of your form of identification, because some people don't have driver's license. Some people don't have any government authorized ID, but they are registered to vote, they are qualified to vote, and they should be permitted to vote. And I think states need to quit having these restrictive things to keep people from voting, just to be sure that you are, in fact, the person who's on the roll and that you're eligible to vote.
Another.
Hi, my name is Christine Jurgens. I am a public school teacher here in Omaha. And my question has to do with, it's been over 60 years since Brown versus Board of Education. Do you think, in your opinion, legal opinion, we've made significant impact in separate but equal? Do you think we've made significant impact in the intent at Brown versus Board?
Versus the Board of Education made a significant impact over these 60 years.
There's no question about the boards of education, the desegregation of schools, the matter of doing away with segregated schools so that you can get a quality education compared to the way it used to be, has improved substantially in many areas. I have been disappointed, however, in some of the school desegregation cases. See, the whole purpose of it wasn't solely so that you could have blacks and whites together, but it was so that you could get quality education. So we still have in some areas, some communities and some schools where those students who are attending those schools are not receiving quality education. And I think that's where the emphasis needs to be placed on, is having every school in every school district so that any student and every student who attends that school can receive a quality education.
I'm going to throw one in here, actually, but I have. What are your thoughts on charter schools?
You know, I don't know anything about charter schools.
Well, very good.
And I don't try to answer things I don't know anything about. That wasn't a problem when I was coming along. So I'm going to let these other younger lawyers who are dealing with it, who have more experience on it, and who know more about that than I do. So I think you can get them to tell you something about charter schools.
And we'll take one last question.
My name is Timothy Ashford, I'm a local attorney. I'm not stalking you, Mr. Gray. I saw you last night, earlier this afternoon, and now. My question to you is, for the audience, you said over and over about the NAACP Legal Defense Fund, and you've mentioned that how you got funding. Will you please explain to the audience, and I'm an attorney and I've got a couple of cases on the 8th Circuit, and we've talked about that, but can you please tell the audience how to go about funding NAACP and various other organizations which are going to fight for the civil rights of individuals?
How to?
Funding civil rights cases through organizations.
Well, let me tell you, an attorney, I appreciate you. I met him a long time ago with the NAACP and happy to know it. He keeps me abreast of what goes on in this city. And thank you for being here. I have tried my best as a lawyer not to get involved in the funding of things. I've been fortunate enough most of the time that there have been organizations in the various cities where I work. For example, in Tuskegee, the Tuskegee Civic Association, they had several organizations there. Same people are members of them, but each one does certain things. There were certain ones who worked on the right to vote and electing people, the political aspects. The Tuskegee Civic Association was the one that raised money for and funded the cases in conjunction with the NAACP. And then we had another one that dealt with other areas. So what I like to do as a lawyer, and the whole civil rights movement really is a composite group of a lot of different people doing different things. Me as a lawyer, I have tried to stick with just the legal aspect of it and hope that these organizations out there will see the need and the fact that we have to be financed and that the cases must be financed, and let them do the financing of it. Then you have other people out there who don't deal with financing and don't deal with that, but they're able to make speeches. You have some who can't do that, who can participate in marches and demonstrations. So what I'm saying is the civil rights movement itself consists of a lot of moving parts, including a very important part is the financing of the cases. But I have tried as a lawyer not to have to be involved in that aspect of it.
Okay, thank you for your questions. And thank you, Reverend Gray and Greg and Kai, for an amazing conversation.
Thank you. Let me just thank the Omaha International Ministerial Association. The president is here, and Mr. Roma here. These are the people who brought me here. See, this question and answer period, when they entered into an agreement with me to come, didn't include me coming to this university. It included having a question and answer period at the hotel right after my speech, so that people will have heard what I said there and then. But to everybody's advantage, they saw fit to bring it here, and you saw fit to invite them, and we're very happy that we have another whole different audience, and we're very happy that you come. And I'm happy for the Churches of Christ who I spoke to on yesterday. I see Huggin is here and Amsters are here. So they've kept me busy with 3 church services yesterday and 2 major events here today. Thank you very much, and come visit us in Tuskegee.
Thank you. Thank you. Thank you, Reverend Gray.
Okay.